you've had read to you a few things that you now disagree with. I did find this opinion of yours, in one sentence of yours, in Ullman versus V. Evans. You say, those who step into areas of public dispute, who choose the pleasures and distractions of controversy, must be willing to bear criticism, disparagement, and even wounding assessments. My guess is you still will hold by that statement here today.
Yes, Senator. I hope that isn't a prelude to a wounding assessment.
Yeah. One area that is of concern to me is an area where you on the court would have a great deal to say, where Congress has really, to a great extent, stayed out, and that is the whole question of where we draw the line between church and state. What we have evolved is a system that is basically very healthy both for religion and for government. And I am concerned that we don't make major modifications of it. In 1984, a speech at the University of Chicago, you, among other things, talked about the 3 tests that are used. And let me quote Justice Powell on what's called the Lemon test. Justice Powell in Wallace v. Jaffrey wrote, "I write separately to express additional views and to respond to criticism of the 3-pronged Lemon test. Lemon v. Kurtzman identifies standards that have proven useful in analyzing case after case, both in our decisions and in those of other courts. It is the only coherent test a majority of the court has ever adopted." In the speech at the University of Chicago, you talk about that test rather critically. You say, if this text is accurate, the 3rd test, no excessive entanglement between government and religion, is impossible to satisfy. Government is inevitably entangled with religion. You then talk about entanglement, though the 3rd part of the test is not simply entanglement, but excessive entanglement. Then in a speech at Brookings, 1985, if this is correct, you say, many observers expected a major recasting of doctrine, but the Supreme Court this past term surprised them by adhering to the old tests. Eventually, however, we may see such a reformulation, not because I think the attitude of the court will change, though of course it may, not because of political pressures, but because, as observers of this area commonly remark, present doctrine is so unsatisfactory. Then let me skip a few sentences. You say, constitutional doctrine cannot separate either religion and law or religion and politics. And I will skip several sentences, but I don't think I'm taking things out of context. A relaxation of current rigidly secularist doctrine would in the first place permit some sensible things to be done. And then I'll skip a sentence, and you say, I suspect that the greatest perceived change would be in the reintroduction of some religion into public schools. Now, do these texts that I have quote you accurately as far as you know?
Yes, they do, Senator.
What do you mean by this phrase, I suspect that the greatest perceived change would be in the reintroduction of some religion into public schools?
I was thinking, there are only 2 cases I've ever criticized about in this area, and they're both very marginal cases. This case, I thought the Supreme Court had gone fairly far when it said, not unanimously as I recall, that a school could not put up the 10 Commandments in the school on the wall, even though it put underneath the Ten Commandments a statement that this is not an endorsement of a religion, it's part of our cultural heritage, as indeed it is fundamental to both the Jewish and Christian traditions. And that's all I meant by that. It seemed to me that it was getting a little, that was a little excessive, I thought. And the other thing I said, some sensible things to be done, I was talking about the Aguilar against Felton case, in which, under a federal program, the City of New York had public school teachers go into private schools, including religious schools, to teach educationally deprived children who were far behind in their subjects remedial reading and remedial arithmetic and so forth. The program was conducted in rooms bare of religious symbolism. The materials used had no religious content. There was no interaction between the public school teacher and the religious people. They often weren't even of the same faith. That passed the first two tests of the Lemon test. It was secular in purpose and did not advance religion, but it failed because they said there was excessive entanglement, since the city had to make sure that religion didn't creep into the program. And that struck me as a kind of an odd thing to strike down a program. The lower court judge who agreed that Henry Friendly, a famous judge, who agreed that the program failed the third aspect of the Lemon test on excessive entanglement because the city had the police to make sure religion didn't get into it, said that it was a program that had done much good and little, if any, discernible harm. And so it seemed to me to be kind of too bad. Now, there was some suggestion, I guess, that if they'd taken the children out of the school and walked them down the block and into a trailer, they could have had the program. And that seemed to me a little odd. But this area is full of line drawing, and sometimes you think they draw the line too far on one side or the other. I have not in any way questioned, and will not in any way question, the basic importance of the Establishment Clause in preventing the establishment of religion, or the basic importance of the Free Exercise Clause. But sometimes, and it's often 5-4, a case like Aguilar or a case like the Ten Commandment case doesn't seem to be as essential to prevent the establishment of religion. But that's on the margin. I'm not talking about anything more than that.
Okay, let me ask another question on line drawing without projecting how you might rule in the future. Let me give you a very practical example. When I served in the House, my colleague, Congressman Dan Glickman, told me about when he was in the 4th grade. Every day, he happens to be Jewish, growing up in a community that was largely not Jewish. Every day, he was excused from the classroom while they had a prayer, and then he was brought back in. Every day, all the other 4th graders were being told Danny Glickman is different.
Yep.
Every day, he was being told he was different. We have the Engel decision, 1962, of a prescribed prayer that was to be required daily. The courts ruled that was unconstitutional. As you reflect on that, was that a sound decision?
I have not ever thought through that subject. This is not an area I ever taught. And the reason I want to say that is that the Washington Post carried a story that at the Brookings Institution, in the speech you quote, I had endorsed school prayer, which is entirely false. But I thought I should bring to your attention, therefore, two letters, one of which to the Post, one of which was printed, one of which was not. The first, and I would like to put these in the record, but I would like to cite them, so thank you. The first is from Mr. Warren I. Sykins, who was a senior staff member at Brookings and ran the seminar program at which I spoke, and he was there. Mr. Sykins doesn't say it in the letter, but he tells me, and I'm sure he wouldn't mind he says it publicly, he's a devout Jew. And he kept notes of it's his program, he kept notes of the evening. And he starts off by saying he's quite concerned about the fact that people It was an off-the-record meeting, a give and take. The people said what happened. He says, whatever one's views are about Judge Bork's qualifications to serve on the Supreme Court, he certainly is entitled to a thorough and accurate review of his opinions. In examining my notes of that meeting, I find no reference to any specific Supreme Court decision, but only the expression of broad concepts and principles. I find no opinion expressed by the judge on the issue of school prayer, but only the comment that the current turmoil in constitutional law may force some revisions. One must remember that the context of this session at Brookings was the airing of a wide range of views on matters of church and state in an aura of reconciliation, not confrontation. While Judge Bork was challenged frequently by members of the seminar, he responded with grace and inquiring mind and willingly extended the discussion period well beyond its adjournment time. But I would like, Senator, since this is a serious matter, and I do not come at this with either a religious or an anti-religious bias. I come at this, but this letter, which was printed in the Post, is from Rabbi Joshua O. Haberman. And he said, it's a good thing that I was there when Judge Bork met with a group of clergy at a Brookings Institution dinner for religious leaders in September 1985, because if I had nothing but your account from the paper of that evening's discussion, I would draw entirely wrong conclusions about Judge Bork's view on church and state issues. Your reporter was not present at the meeting. I was. As a rabbi with a strong commitment to the separation of church and state, I would have been greatly alarmed if Judge Bork had expressed any tendency to move away from our constitutional guarantee of religious freedom and equality. I heard nothing of the sort. As a matter of fact, the rest of the letter is so laudatory that I think it would be improper for me to read it, but I would like you to read it, Senator.
All right. I shall.
Because I have never taken a position on school prayer. I have never taught the school prayer cases. I have never written about it. I have never even thought my way through the problem. The only thing I'm convinced of is that the principle of non-establishment is essential to our society, and I know the framers thought so, and particularly with the memory of the religious wars in Europe in mind. And I think the principle of free exercise is also vitally important. But where the adjustments are made at the margin is a question that goes case by case.
One of the things in this whole area we also have to do is to protect the rights of religious minorities, Seventh-day Adventists, Jehovah's Witnesses, and so forth. The decision on saluting the flag by the Jehovah's Witnesses, any reflections upon that?
I have never taught that case or thought about it.
Moving to...
may I say something? There is so much in a constitutional law casebook that in one semester you have to choose and select pretty severely. So there are just areas I just had never taught.
And let me just add, and I think my colleagues would agree, whether they happen to be for you or not, you have gone into much greater detail on cases than any recent witness we have had before this committee. Let me get into an area where I have some concerns with your answers both yesterday and today, and that is that I think there is I sense a tendency to view the Constitution as fairly rigid in terms of the expansion of liberty. Supreme Court is the basic guarantor of liberty, and as we look at the application of it, wherever possible, that liberty should be expanded. And if I may quote, you mentioned Justice Harlan in the Griswold case that Senator Biden mentioned. Justice Harlan, in his opinion, referred to his earlier opinion in Poe v. Ullman. Justice Harlan says, in a sentence that I had never seen, or a couple of sentences I had never seen before, but I think really are significant, and I'm going to use them on other occasions in the future. In that opinion, he says, liberty is not a series of isolated points pricked out in terms of the taking of property, the freedom of speech, press, and religion, the right to keep and bear arms, the freedom from unreasonable searches and seizures, and so on. It is a rational continuum which, broadly speaking, includes a freedom from all substantial arbitrary impositions and purposeless restraints. Pretty powerful, pretty eloquent. And it seems to me, as we look at some of these cases, that we have to look at how liberty can be expanded without doing harm. At one point, in a speech in Berkeley, 1985, you say, and I'd be interested in any comments you have here, what a court adds to one person's constitutional rights, it subtracts from the rights of others. You believe that is always true?
Well, yes, Senator. I think it's a matter of plain arithmetic. If a court, I think our Constitution gives a constitutional right or liberty in areas where the Bill of Rights or the Civil War amendments don't prohibit it, of citizens to sit down and elect their representatives and make their laws. If a court strikes down such laws on behalf of a plaintiff claiming a liberty, it automatically deprives the first group of its liberty. So that what you're talking about here is a redistribution of liberty. Now, that seems to me to be arithmetically solid. There's no way you can get around it. But where the Constitution says the majority doesn't have that liberty, they shouldn't. Where it says they do have that liberty, they should.
But that arithmetic equation isn't always quite equal. In other words, if you give slaves freedom, you, I suppose, and using your analogy, you then take away the freedom of slave owners.
But that is a redistribution of liberties commanded by the 13th Amendment to the Constitution. And I certainly have no objection to a redistribution of liberties whenever the Constitution requires it or authorizes it. No objection whatsoever. What I was talking about was judges who make up new liberties and say that they're expanding liberty. Well, they are for some people, but they're contracting it for other people. That's all I was saying.
All right. We've talked about the 1954 Brown decision. 1954, you were an attorney for 1 year. Do you recall what you thought about the Brown decision at that point?
Oh, yes, I did, but I thought, I was not an attorney. I was working then on the, Edward Levy hired me as a research associate on what they called the antitrust project at the That's where I picked up such basic economics as I got. I recall that in law school, I think it was argued and then re-argued, and I always thought it would come down the way it did. I must confess that at that time, it seemed to me good enough that it come down that way because that was the moral result. And that's all I needed. Since then, I have tried to give a rather more sophisticated constitutional support for the case.
What about the 1942 decision, the court on Japanese Americans? I mention this because I recall my father, we lived in Eugene, Oregon, and my father speaking up and saying this is wrong to do to Japanese Americans. And I remember so few people standing up, and a very unpopular stand my father took. And I remember that even as a very young man, young boy then, the court failing to stand up for Japanese Americans.
It certainly did. It certainly did. It failed, and I think that case has been regarded as a constitutional disaster ever since. It was a period, I guess, I guess when the interning took place, I must have been around 15 or 16, and I lived in the East. So I don't have any firsthand experience with it, but I do recall that there was considerable hysteria about the war and about the rumors of what was going to happen on the West Coast with sabotage and invasion, and I think that was probably accelerated or multiplied by racial animosities as well, and the Supreme Court should have made sure that something real was going on, which it wasn't. There was no real espionage or sabotage program, but the Supreme Court took the word of some authorities for it, and that was that. And I think that was a constitutional disaster.
And as you examine Robert Bork, if you're in a situation where you're demanded to make a very unpopular decision, but it complies with the Constitution, is your personal constitution of such a nature that you can make such an unpopular decision as it would have been in the case of Japanese Americans?
I think so, Senator, because as you may have noticed in these hearings, I've been taking unpopular positions frequently in my life. I remember when I was one of the only two professors at all of Yale, not the law school, at all of Yale, on a faculty of 2,000 who would admit to being for Goldwater. And every morning, as I walked into work, I had to have 15 arguments. By the time I got to my office, I needed a shower again. It was that. No, I've been in a minority position many times. Don't love it, but I'm not afraid of it.
What about, I had my staff dig out the Dred Scott decision, and I read the majority opinion by Justice Taney. Sounded an awful lot like Robert Bork in terms of saying we can't read into the Constitution what is not there, when they denied free blacks the right to be citizens.
Well, that doesn't, Senator, I take that a little hard. That does not sound a lot like Robert Bork. It happens to be that the Dred Scott decision, I think, is the first time the doctrine of substantive due process was raised by the Supreme Court. Substantive due process being the doctrine that the Due Process Clause imposes limits on government, and the court makes it up. It's one of these free-floating things, again, which the court used in the past to strike down economic regulation. Chief Justice Taney in Dred Scott said that it would be a violation of the Due Process Clause to take away a black slave from a white owner. So you see that these doctrines, which give judges power to make up their own constitutional law, which was what Taney did in that case, don't always produce results that today we think are fine. Sometimes they produce disastrous results, and Dred Scott produced a disastrous result not only for Dred Scott, but for the nation and for help to lead up to the Civil War.
Let me just quote the Chief Justice at that point. It is not the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belonged to the political or lawmaking power, those who formed the sovereignty and framed the Constitution. The duty of the court is to interpret the instrument they have framed with the best lights we can obtain on the subject, and to administer it as we find it according to its true intent and meaning when it was adopted.
Senator, anybody, the devil can quote Scripture, and Taney can talk about original intent as people did. The fact is, he used the Due Process Clause in a way he never should have used it against the black man, and Curtis's dissent, I think, is the original intent position in that case.
Let me ask one more on the Griswold case, where, incidentally, the Ninth Amendment grew out really of Hamilton and others questioning whether the rest of the Bill of Rights was going to be so explicit it would deny other rights. And so Madison wrote the Ninth Amendment. In theory, if the state of Connecticut can ban contraceptives could not, in theory, you're a legal theorist, could not, in theory, the state of Connecticut require the use of contraceptives?
I may be a legal, I doubt that I'm even a legal theorist. I engage in legal theory from time to time. But I don't usually engage in legal theory instantly. I never thought about a statute requiring the use of contraceptives, nor do I know exactly how you would police it or what you'd do with it. And I don't want to imagine how you'd police it.
That is a problem with the original law, of course, too.
Yes.
But I guess my concern is I do not want someone in the court who is going to be so rigid in the application of liberty that there is not some expansion and growth in liberty for the people of this country.
Let me put it this way, Senator, and this is the best I can do. If you'll read those cases, I've got a good voting record on civil rights and constitutional rights and so forth, but if you read the one essay that I wrote, extended essay on this, largely because my good friend, now Justice Scalia, was going the other way on the case, and we got into a wrangle about it. And that's Ullman against Evans, in which I apply and expand a First Amendment freedom for the press. I do not believe that constitutional freedom should be given a narrow or a crabbed construction, and I have never given such a narrow or a crabbed construction to them. In fact, I think just the other day, I think a case came down on the double jeopardy clause in which I reversed a new sentence on double jeopardy grounds. That I should say, because before somebody makes the accusation has been made, that was a case that was voted on and assigned to me long before this nomination came up. But if you will, assigned to me by Judge Mikva, who was the senior member of the panel. If you look at my opinions, you'll see no reason to expect any crabbed or narrow interpretation of any clause, and those clauses have to evolve as circumstances and technologies and other things change, so that they're continued to be given their full and fair value. But, Senator, I must confess, if you say to me, here is an outrageous statute, and that's all the lawyer can say to me, that is not enough for me to strike it down. It may be one of the worst statutes the world has ever seen. Why should I engage in hyperbole myself? It may be just a terrible statute, and you and I would agree that no civilized community could really live with a statute like that. But unless I, as a judge, unelected, unrepresentative, have a warrant in the Constitution, fairly applied, fairly interpreted, I will not strike it down because I regard it as outrageous.
And I would not want you to. But I guess I would want you to do what Justice Harlan referred to in that Povia-Ullman case that I saw, that I read just before, to see that we do not have, let me see if I can find it here, read it just once again. He says, it is let me read the whole thing again. This liberty is not a series of isolated points pricked out in terms of the taking of property, talking about the liberty, use of the word liberty in the 14th Amendment. The freedom of speech, press and religion, the right to keep and bear arms, the freedom from unreasonable searches and seizures, and so on. It is a rational continuum which, broadly speaking, includes a freedom from all substantial, arbitrary impositions and purposeless restraints.
That purpose, I think, can more usefully be served, and I hate to bring this up again, by a reasonable basis test under the Equal Protection Clause. Because if you get an unreasonable restraint or a purposeless distinction, it's not going to meet a reasonable basis test. And I suppose I should fill that out by saying that I think the court, using the reasonable basis test, which Justice Stevens does and maybe some others do, I think I would come out just in about the same position that the court is in on such matters as racial discrimination, gender discrimination, and so forth. I just regard it as a much more satisfactory methodology than this each group has its own tier of analysis kind of constitutional theory that we have now. But I don't think the results would differ substantially. I can't think of a Supreme Court gender discrimination case that would come out differently in my mind under a gender discrimination case. And I think that is a better constitutional methodology to accomplish what Justice Harlan was saying there than is just sort of a substantive due process methodology.
I thank you, Judge Bork, Mr. Chairman.
Thank you very much, Judge. I know we will be pleased to know that's it for today. We have finished one round of questions from all of myself and all of my colleagues. Tomorrow we'll resume at 10 o'clock, and with a little bit of luck, we'll be able to finish tomorrow. But again, why don't we, you and I, confer at, we'll probably break around noon or 1 tomorrow again, and we'll confer to see how late we go, if we have to go. Yes.
What will be the procedure tomorrow on time?
The procedure tomorrow, in my view, will be, since a number of senators have indicated they thought they have substantial questions. I don't mean to imply there's anything new. I mean to go back over material or new material. I don't know. That we would stick to the half hour. If senators don't wish to use the whole half hour, they can. If they wish to use the half hour, and hopefully that will save us from I shouldn't say. Hopefully that'll allow all the questions to be asked at that time. But there'll be half hour again. Is that all right with you, Judge? Is that the best the half hour question period?
Oh yes, that's fine.
Fine. With that, the hearing is adjourned until tomorrow morning at 10 o'clock.
Just contacted by former Dean Paul Marcus of the University of Arizona, and he's informed me that no one has secured his approval for
in our society. While I heard your answer on the pro bono work, are there other things that you have done in your 60 years working with the less fortunate, helping, volunteering to work with the retarded